Hello everyone and welcome to our webinar on the amazing national reforms that have taken place recently in Parliament on the Environment Protection and Biodiversity Conservation Act. My name is Rachael Walmsley. I'm the Deputy Director of Policy and Law Reform here at EDO, and I'll be running this webinar today and introducing you to our amazing law reform team to give you the lowdown on everything that's happened. But first of all, I would like to acknowledge that I'm coming to you today from Gamaragal country of the Eora Nation in Sydney, and I pay my respects to elders past and present. I'd also like to extend those respects to the elders past and present from all the lands we're calling in from today, and acknowledge that those lands were unceded, always was and always will be Aboriginal land. Just a little bit of housekeeping. This webinar today will be recorded and we'll be sharing the recording and the slides afterwards. There's a lot of technical detail in the slides, so don't feel you have to fiercely take notes. We will be sharing the recording and the slides afterwards. We're also inviting you to ask questions. We will have a Q&A session at the end. So please post any questions that you've got in the chat, in the Q&A tab, and we'll get to them. If we don't get to your question today, we're going to be publishing a lot of analysis and further thoughts in the coming weeks. So we'll absolutely get to your question at some point, but please feel free to put them in the Q&A tab for us. So hopefully everyone has joined, and so we might kick off the substantive part of the webinar today. Just before I introduce the amazing team, I just wanted to give a bit of a snapshot of what got us to this point within national law reform. For those of you who I know, this has been a long time coming, and many of us in the who work in environmental policy have worked on this for a really long time. Some of you will be familiar with our national environment law, the EPBC Act, others of you less so, but I think to summarise it, why this is a bit of a momentous event that we've actually had legislation passed, we need to look back. So this Act came in 1999, and we've had 25 years of an Act that hasn't really worked, hasn't protected our most precious matters of national environmental significance. So this Act is reviewed every 10 years. It was reviewed in 2010. It was reviewed in 2020 by Professor Graham Samuel. And each time, whenever there's a review or a Senate inquiry into this particular bit of legislation, the findings are the same. The Act is failing nature. The Act isn't working for business. It's very procedural and discretionary, and it's not delivering outcomes. Anyone who's read a State of Environment report will agree it's totally depressing reading. The trajectories for our threatened species and our places like the reef and our World Heritage are going down. What we actually need is law reform to turn that around at the national level. You may recall we've had a few attempts at passing legislation. During the last term of Parliament under Minister Plibersek, we had a staged approach of nature positive bills. That did get us an expanded water trigger, so the federal government looking at the water impacts of large coal and unconventional gas. We got a nature repair market. We had bills introduced to establish a new National Environment Protection Authority and a nature positive bill. But as you may recall, at the very last dying weeks of that term of Parliament, that process was exploded by Roger Cook and the Prime Minister, and somehow, instead of wide-scale reform that we desperately needed, we ended up with a salmon bill that was a carve-out for the Tasmanian salmon industry. So last term of Parliament was a fail in terms of national law reform, really, if you look at what Graham Samuel said we need to turn these laws around and actually start protecting nature. So as you know, after the election, the majority government in power, a new minister was installed with an ambitious mandate to get bills delivered, get environment bills through before Christmas. We have to say we've done years and years of work on this. The arbitrary kind of deadline that the bills must pass by Christmas was purely political. It was a kind of a KPR of Minister Murray Watt to get these bills through. So what we've seen this term of government is some selective consultation with business and certain environment groups, supported by a huge alliance of all the groups that we've been working with and all the interested stakeholders who've been working on this for years. A very strange process in the last few months, culminating in 1,500 pages of legislation being introduced right at the end of October, went into the House of Representatives, and it was passed by the House 1 week later on the 6th of November, which is extraordinary if you think of the scale and importance of these reforms. It was sent very swiftly to a Senate inquiry. EDO and others went down to Canberra, presented evidence at that inquiry. And as we saw at this Parliament, this opportunity, there were 3 options of what could happen. First, this Parliament could fail to pass the bills again, blow up the process again, not pass any legislation, and that would leave us with a broken act that's failing nature. So the status quo, and that is not working for the climate crisis, the extinction crisis. Option 2, the government could have passed the bills as proposed, which were highly inadequate, really, really problematic bills, or worse still, they could have actually weakened the bills, as was being recommended strongly by the business and industry community. So the legacy of the Parliament, had they gone with that option, would actually have been to make a broken act far, far worse. The third option, the one we supported, was to work to find a pathway through the Senate where we actually got amendments to try and fix the bills, the worst bits of the bills, and actually take a step forward and build the foundations for national environmental laws that actually protect nature. So the EDO team has been working tirelessly on this, and we were able to work with so many groups who are on the call today, and partners and alliances and scientists and First Nations people. So many people care about these laws, and work through this really, really tense negotiation process and a parliamentary circus, as it always is at the end of a parliamentary term. And today what we'd like to do is just take you through what happened in terms of 8 of the key elements of what we've got in the new laws, some of the good steps forward that are foundations we're working on, and some of the problematic areas of the legislation where we really, really need scrutiny and vigilance and a lot of work to make sure we keep an eye on what's happening. And we want to just take you through some of those key bits. But I would like to say this is momentous that we actually got legislation passed through a progressive pathway, but it's in no way the end of the story. This is actually just the beginning of all the work that needs to happen now to actually implement these laws, establish standards and regs, and actually make sure these laws work. So we'll be sending around some information later today about the next steps. But right now, gives me great, great pleasure to introduce the awesome EDO law reform team who've been putting blood, sweat and tears and extreme hours into this process pretty much for the last few years, I would have to say, but especially recently. First of all, Revel Pointon is our managing lawyer. We have Cerin Loane is our special counsel. Rachael, our senior solicitor. And we are freshly joined from Parliament by a new team member, Zoe Newmeyer. So these amazing, amazing lawyers will be taking you through some of the key points of the changes today. And I would just like to shout out the amazing job that they have done on 1,500 pages of technical legislation and 400 odd pages of amendments. It's been extraordinary. So we're going to try and distill that down into an hour here. Obviously, it's covering a lot so that you will get the detail in the slides, and we can follow up with other questions, and we will publish more in due course. But right now, it gives me great pleasure to hand over to Revel to run through the outline of today. Thank you.
Thanks, Rachael. If we could share the slides, please, Alex. Wonderful. I will just pop us over to the outline. As Rachael mentioned, we're going to go through, I guess, 8 of the key reforms that came through with the bills being passed recently. We'll start with some of the reforms that have led to new mechanisms that may actually strengthen environmental outcomes under the EPBC Act. And then we'll go through some of the reforms that further work is definitely needed to ensure that there are safeguards in place for these new changes that will potentially have risks otherwise of poor quality environmental decision making. And we'll wrap up with what the next steps that we can all be involved with to make sure that this package is as strong as possible going forward. So I will pass over to Rachael Chick to start us off.
Thanks, Revel. Hi, everyone. As you've probably heard, the package included acts to establish 2 new institutions. The first institution being the long-awaited National Environmental Protection Agency, or NEPA, which was a key commitment of this government. The NEPA, through its CEO, has been given responsibility for compliance and enforcement activities under the EPBC Act and some other Commonwealth environmental legislation. However, the Minister retains responsibility for environmental assessment and decisions on approvals under the EPBC Act. The EPA would only be able to exercise these powers under delegation from the Minister. In terms of governance arrangements, there's no independent board to govern the EPA. The CEO will be appointed by the Governor-General on the Minister's satisfaction that they meet the required criteria. The Minister is able to issue a statement of expectations to the EPA, but is prohibited from directing the EPA in the exercise of the EPA's statutory functions. One of the Samuel Review's key criticisms of the EPBC Act related to compliance and enforcement of the Act. The package of amendments includes some improvements in the tools that will be available to enforce the Act. One being a new power to audit whether a person is complying with the Act. 2 is a new power to issue environment protection orders, which are similar to stop work orders in other jurisdictions. However, I note that this power was watered down by the government in its Senate amendments, and now they can only last for 14 days with the option to extend once for a further 14 days, which was a disappointing amendment to see. And 3, and one which there's been a lot of media attention given to, the package includes significantly increased maximum penalties for offences under the EPBC Act. The second new institution is Environment Information Australia, or EIA, which will be part of the department under a statutory senior executive position of Head of Environment Information Australia. The EIA is established to improve the availability and accessibility of high-quality national environmental information and data. The acts establishing both institutions will commence on the 1st of July 2026. And we look forward to seeing how they operate. Now over to Revel to speak to us about the National Environmental Standards.
Thanks, Rachael. So National Environmental Standards were a centrepiece of Professor Samuel's recommendations in the most recent independent review of the EPBC Act. And the point behind them is that they are to provide prescriptive, non-discretionary standards as to help guide decision makers in making decisions about how or whether matters of national environmental significance can be impacted. And so under the bill, the Minister may only approve an action or class of actions, strategic assessments, bioregional plans, or even devolution of EPBC powers if satisfied that the decision is consistent with any national environmental standards prescribed for that decision. The reference to the term consistent is actually a win that came through the negotiations last week that the Greens pushed for. It used to be not inconsistent with any national environmental standards in the first draft of the bill. It's great that this is now changed to a more positive duty, that the decision maker must ensure the decision is actually consistent with those standards. So under the bill, the Minister has the power to make standards, but it's not required actually to make any standards, and there are no standards listed in the bill that need to be made. So if a decision was made under the Act once, so these reforms in terms of making the standards are actually in effect right now. They commenced on the 2nd of December. But without any standards in place, there's nothing for the decision maker to actually consider. Once they're drafted, there are 2 draft standards that are open for consultation now until the 30th of January, one for matters of national environmental significance to help guide decision making, and the other for offsets particularly. And once the public consultation is finished on them, they'll have to be tabled in Parliament as legislative instruments, and they can be subject to disallowance motions if any members of Parliament aren't satisfied with them. As I mentioned, all standards, once there are standards in place, there will need to be a regulation to prescribe which standard actually applies to each decision. Not all standards automatically apply to a decision. And so work will be needed first in ensuring that the full suite of standards that were recommended by Professor Samuel is actually put in place by the government, and then that the appropriate standards are actually prescribed for each of the decisions. There is a review mechanism under the new reforms that provides that each standard has to be reviewed within 18 months of being established, and then every 5 years after that. And a no regression principle applies, which means that once a standard is being varied or revoked, the level of environmental protection or community consultation that was provided under the standard cannot reduce through the process of those amendments. However, that doesn't apply for the first within the first 18 months. After 18 months, it will apply. I will throw now to Cerin to discuss unacceptable impacts.
Thanks, Revel. I'm talking about 2 new safeguards that have been put into the Act through these reforms. So the first one relates to unacceptable impacts. This is a new safeguard in the EPBC Act that provides that actions must not be approved unless the Minister is satisfied that the action will not have an unacceptable impact on a matter of national environmental significance. So this requirement applies not only in the case of individual projects, but also to approvals given under other pathways, such as strategic assessment, bioregional plans and accreditation. However, it does not apply in the case of projects that are determined to be national interest projects. The introduction of a new unacceptable impact provision is an important step forward, as it introduces into the EPBC Act for the first time a mandatory refusal if there are unacceptable impacts. This type of provision that compels a mandatory refusal is not common in environmental law across Australia. But what does unacceptable impacts really mean? Well, there is a new definition. It's in section 527F of the Act, and it's actually a lengthy table that sets out criteria for determining unacceptable impacts for each matter of national environmental significance. And you'll see there in the slide an example. So in the case of threatened species in the critically endangered category, an unacceptable impact would be a significant impact that seriously impairs the viability of the listed threatened species or causes serious damage to critical habitat of the listed threatened species where the habitat is irreplaceable and necessary for the listed species to remain viable in the wild. So it's quite a technical definition and will no doubt need ecological expertise to help inform a decision about whether or not there are unacceptable impacts. We're already hearing from ecological experts that the definition is undermined by vague language and undefined thresholds, meaning that establishing unacceptable impacts may be difficult. I also note that the provision is drafted in terms of the Minister being satisfied that there are not unacceptable impacts, so that builds discretion into the application of the test. And there was also a last-minute change in the Senate that changed the definition from likely to have or will have to simply will have unacceptable impacts. So the bar that needs to be met there is now higher. So together, the drafting means that establishing unacceptable impacts in practice might be difficult. But we need to recognise that it's a step forward with this new safeguard in the Act that will require mandatory refusal for unacceptable impacts. And no doubt, EDO clients and others in the community will be keen to see how this new safeguard is applied in practice. And as part of community engagement in processes under the Act, we'll be putting information before the Minister to help inform decisions as to whether or not there are unacceptable impacts of a project and to compel that mandatory refusal where relevant. So the other safeguard I wanted to talk about is the net gain safeguard that's also been included in the Act. So there is now a new requirement that actions can only be approved by the minister if the minister is satisfied that the approval will pass the net gain test. So this means that where there are residual significant impacts, a project must result in a net gain. This will essentially be achieved through the use of offsets. So approvals will be able to be conditioned to require either direct offsets or offset payments, which will be known as restoration contribution charges. And I will talk a little bit more about offsets in a moment. But in terms of this net gain test, the baseline will be the net gain measured against the status or condition of the environment at the time of the decision. But what actually is a net gain? Well, we don't know yet because that will be prescribed in the regulation. So for example, will it be a fixed percentage, 5%, 10% on the status of the environment at the time of the decision, or will it be something different? Will it mean different things for different matters? We just don't know yet. But if it's not prescribed in the regulation, then it will otherwise be at the minister's discretion. So the minister will be able to determine when making a decision whether or not the minister is satisfied that there is a net gain. So again, an important new safeguard in the Act that is intended to deliver outcomes for the environment, but the detail about what constitutes a net gain is not yet known, and how it will be applied in practice and what the actual outcomes will be on the ground is yet to be seen. I'll throw now to Rachael to talk about some of the changes that have been made in relation to forestry and land clearing.
Thanks, Cerin. I have the pleasure of speaking to some of the most significant and positive changes that have just been made to the Act. Firstly, regional forestry agreements. For over 25 years, logging of Australia's native forests has been exempted from the protection and oversight of the EPBC Act through a specific carve-out for forestry operations undertaken in accordance with a regional forestry agreement, or RFA. The amendments to the Act secured by the Greens have at long last legislated an end date for this exemption in 18 months on the 1st of July 2027. This means that any native forest logging that is likely to have a significant impact on a matter of national environmental significance that occurs after that date must be subject to the EPBC Act. This is a momentous change. It's one that legal and ecological experts have long called for, and is a significant improvement to the integrity of the EPBC Act as Australia's national environmental protection law. I know that many of you watching have played a role in this and campaigned over many, many years. Congratulations and thank you for your efforts over the years. However, although this is a significant improvement, it is important to note that the government has stated its intention to work with affected states to accredit forestry operations to enable those operations to take place without needing individual approvals for each individual operation. So, for example, through bilateral agreements. This will require close and ongoing scrutiny to ensure that any accreditation ensures significantly better assessment, conditions, enforcement, and on-ground environmental protection than currently exists. This includes input on proposed bilateral agreements, but also on any relevant national environmental standards, given the government's stated intention to ensure that forestry operations comply with national environmental standards. The second significant improvement secured in the Senate relates to land clearing. Australia is a global deforestation hotspot. Until now, most of that deforestation has been undertaken with no effective federal oversight under the federal environmental law. In the past decade, much of this deforestation has occurred in New South Wales and in Queensland, including in the catchment of the Great Barrier Reef, which has led to sedimentation and other pollution impacts on the World Heritage listed site. The amendments that have just been passed have gone some way to closing a loophole relied on by proponents to do this clearing, by making it clear that the continuation of use exemption in the Act does not apply to certain land clearing. Specifically, vegetation clearing will be subject to the EPBC Act assessment and approval, where it will or may have a significant impact on a matter of national environmental significance, and firstly, if it's vegetation within 50 metres of a watercourse in the catchment area of the Great Barrier Reef, a watercourse, wetland or drainage line, and two, vegetation anywhere across Australia which has not been cleared for 15 years or more, where it's not a forestry operation. Both of these amendments commenced immediately on Tuesday, the 2nd of December, so last Tuesday, which was the day after royal assent, to reduce the risk of panic clearing. However, laws can only be as effective as their enforcement. We welcome the Minister's confirmation in Parliament that the new provisions regarding agricultural land clearing and enforcement of those provisions will certainly be a priority for the new National Environmental Protection Agency. Environmental and community groups will have a significant role to play in holding the government and EPA to account on this. I will now hand over to Cerin to speak to offsets.
Thanks, Rachel. A topic I expect many people on the call are interested in hearing about. So there will be a new framework for biodiversity offsetting under the Reformed Act. So up until now, offsets under the EPBC Act have been applied in accordance with the Commonwealth's policy for environmental offsetting. That policy will be replaced by a new framework that includes both legislative provisions in the Act and a new national environmental standard for environmental offsets. So a few key things to note about this new framework. The first is that the mitigation hierarchy is now better embedded in the Act, and it will require that the Minister considers whether the proponent has taken appropriate measures to avoid, mitigate or repair the impact or damage from the proposed action. But where there are residual significant impacts, the framework does allow for those to be offset, and that will be implemented via conditions on the approval that will specify the offset requirements. There will be two types of offsets available: restoration actions, which are essentially direct offsets, and restoration contributions, which is essentially payment into a fund as a way of satisfying your offset obligation. So this latter option of paying into a fund has been a concern for many stakeholders engaged in the EPBC Act reforms, having learned from the experience in other jurisdictions where payment into a fund has been available. So there are ongoing concerns about offsets, including that payment into a fund does not necessarily deliver the outcomes for the environment needed. And there's a number of reasons why that might be the case. First, there's often a delay in establishing offsets using this method. So once a proponent pays their contribution into the fund, they have essentially satisfied their offset obligation and can go away and carry out their project. And it might be some time before the money that's been paid into the fund is used to establish the offset. So the damage from the impact may have happened before the benefit of the offset is realised. And there's also examples of cases where money's been paid into a fund, but then a suitable offset has not been able to be found. And so the money in the fund cannot be spent on creating a suitable offset that compensates for the specific impacts of the project that has been approved and carried out. Now, in jurisdictions like New South Wales, where a fund like this exists and these concerns have been raised, the government is taking steps to restrict the way in which the fund is used to address some of the concerns raised by stakeholders. Yet, despite the lessons learned in those jurisdictions, the federal government has decided to proceed with the model that allows for restoration contributions as part of its offset scheme. There was a last-minute amendment made to the bill in the Senate intended to provide a safeguard for this part of the framework. So the last-minute amendment would allow the Minister to make a declaration under a new section 134AA to declare that certain matters of national environmental significance are not suitable for offsetting via this restoration contribution. So that is, the Minister can declare that an offset payment would not be available for certain matters. So the idea behind this new power is that the Minister could, for example, declare that a certain species that is known to be scarce or not amenable to offsetting is a type of species for which you cannot do an offset payment as a way of meeting your offset obligation. And there's still a lot more work to be done around offsets. So as Revel mentioned earlier, we're going to have new national environmental standards, and there will be one for environmental offsetting. A draft national environmental standard for environmental offsetting is out for comment at the moment. It will be the place where the principles and rules for offsetting will be set out in detail. And that's currently on exhibition and open for public comment until the 30th of January. There will also be methods or calculators that need to be developed, and they will guide how the restoration contribution amount will be determined. So we will be engaging with the development of those instruments to try and ensure the rules are as robust as possible. We want to avoid the types of scenarios where offsets are not compensating for the specific impacts of an approved action. And we've got a couple of case studies to demonstrate, how our concerns are playing out. So we've got a couple of case studies here. The first being a proposal that includes the removal of nesting trees of, say, the Carnaby's cockatoo, which is an endangered species under the EPBC Act. And so the proponent may be given approval to carry out its project that removes those nesting trees. And one of the ways it can offset its obligations is payment into the fund. And so it does that, it pays the money into the fund, and then it goes away and carries out its project. Meanwhile, the money's there in the fund, the restoration contribution holder tries to find a direct offset for that money, but can't do so. And so under the proposed rules in the draft standard, the restoration contribution holder can propose an alternative way of using that money. So it might be that they can instead carry out weed management in the forests of southwestern Australia, where this cockatoo lives, but it's not actually replacing the nesting trees that have been removed as part of the project. Another example is clearing for grazing land, so large area vegetation that's habitat for multiple threatened species, including the greater glider, and it could be approved with payments made into the Restoration Contributions Fund. The proponent in that case has satisfied its offset obligation, can go away and undertake the project, but now the restoration contribution holder may find that it's unable to find a suitable offset that includes greater glider habitat. And so it's left with the money, the habitat's been destroyed, but there's no suitable offset available. So it's through the rules in the standards and the calculator that we want to make sure that we've got tight rules as possible, so we're avoiding these situations where the impacts of a particular project are not able to be offset through suitable offsets that actually compensate for the impacts that a project has had. And now I'll pass over to Revel. She's going to talk a little bit more about some of the new assessment pathways that have come out through the reform process.
Thanks, Cerin. So there are a number of new pathways that allow fast tracking of development through the EPBC Act. There is facilitation of devolution of EPBC powers through these reforms, and there are extensions to carve-outs, so exemptions from the EPBC Act, applying it all to decision making. I'll run through each listed in turn with a bit more detail. But it is important to note that out of the negotiations, the reforms as passed actually exclude fossil fuel actions, and that includes coal, oil and gas activities, and potentially exploration. Minister Watt actually confirmed in the Senate last week, not just production and extraction. And so those are excluded from all of the fast-tracked pathways. And also the water trigger still remains unable to be devolved to other state or territory governments or other entities. And so the water trigger applies to unconventional gas projects and large-scale coal mining. It is a very important way of ensuring better management of our water resources, and it's wonderful to see that it still cannot be devolved, given it is obviously of national interest, as are all of our matters of national environmental significance, though. So jumping first into streamlined assessment, this is a new pathway that is available under the EPBC Act. As it's drafted at the moment, it is the weakest pathway that exists under the Act. All the minister needs to be is satisfied that there is sufficient information in an application that's put forward for referral under the Act, and the minister made it for them to actually make a decision on the impacts to matters of national environmental significance, and then the minister can choose that this pathway would apply. There would be still consultation on the referral of the application to the EPBC assessment as to whether it should be assessed or referred or not, and that would just be 10 business days. But once the streamlined assessment pathway is chosen, there's no more consultation, no more engagement with the public. A recommendation report must be drafted as soon as possible, and a decision has to be made within 30 business days of choosing the streamlined assessment pathway. So an incredibly quick process. As it currently is drafted, there is no limit on the type of action or the level of impact that a streamlined assessment activity can actually have for this pathway to be chosen, except just a reminder that fossil fuel actions cannot move through this pathway. So work is definitely needed for regulatory provisions to be introduced, which actually limit what kinds of activities can access this pathway, and ideally provide some guidance around the type and level of environmental impact assessment that's needed for the minister to be satisfied that they have sufficient information. Also, consultation requirements could apply to proponents prior to referral for this activity to ensure that there is more robust consultation on the environmental impact assessment documents themselves. I have a case study just to give you a flavour of, under the current framework, what the risks are and why those regulatory provisions are just so necessary. This is a hypothetical example of McMansion Mines. They want to develop a critical mineral mine next to a national park and a drinking water catchment. Highly sensitive areas. They obviously, as with any proponent, want it to be approved quickly, and the state and federal governments in this case also want it to be approved quickly, interested in the jobs and the royalties and getting critical mineral mining off the ground. The mining company puts together a very large 5,500 page EIS statements, environmental impact statement, sorry. This is all prior to referral to the federal government. Maybe it's largely copied from other projects. We have seen that in EISs to date, just copies and pastes from other project reports. Maybe it's even created by ChatGPT, but no real environmental assessment is undertaken, or very little site-specific activity is undertaken for the assessment. The economic assessment might even be made up to make the numbers look big. We've definitely seen that also in our challenges to the environmental impact information put forward by mines in the past. So the EIS is referred under the EPBC Act for assessment. The public has that initial 10 business days just to comment on whether it should be approved under the Act, should be assessed, sorry, under the EPBC framework. The Minister congratulates the mining company for pre-undertaking so much work to put together this EIS, and decides, I've got enough information to allow this mine to move through the streamlined assessment pathway. A recommendation report's drafted in 2 weeks. There's no consultation on the conditions that are quickly whipped up around it, or the level of assessment of the EIS and whether it was adequate in that very short time frame. And then the Minister approves the application in 30 business days after that decision that it's a streamlined assessment. Obviously a very concerning scenario, so we will be putting a lot of advocacy forward around why the regulation really needs tight provisions on what can move through this framework. So moving on to devolution of EPBC powers. So under the current EPBC Act, pre-reform, there were provisions allowing for devolution of particularly assessment pathways under the EPBC Act, and that applies in Queensland, New South Wales, Victoria, possibly other jurisdictions as well at the moment. And so bilateral agreements were entered between the federal and state governments, allowing for the assessment at the state level to be sufficient to cover off on EPBC processes as well. The bill, as passed, facilitates greater uptake of devolution of approval powers as well. There are, however, new criteria placed on a decision maker when they're accrediting whether a framework should be able to have powers devolved to it. And that includes consistency with those national environmental standards, whichever ones are actually prescribed for that decision. That decisions must not lead to an unacceptable impacts, and that the net gain test is provided for, and amongst other criteria. There is also a new requirement that was won through the negotiations last week that accreditation of assessment processes must be in place before accreditation of approval powers occurs. But this doesn't apply for RFA activities, as Rachael mentioned. It also ensured, like, as we know, the standards need to be in place for them to actually apply to this process. So we really recommend, if you've got a chance to write to the minister or any way of influencing in certainty that there is actually a full suite of standards and regulations put in place before accreditation occurs under these reforms to actually make these new criteria meaningful when we're devolving our EPBC powers. There's a requirement for the minister to be able to call in activities under a bilateral agreement. That was only optional in the previous Act. Now it's a requirement. And there are regular reviews required of whether the accredited frameworks are meeting the requirements. So more work to do in this space, though, to make sure that it's not incredibly risky in terms of devolving EPBC powers of approval away from the federal government. And I'll pass to Cerin to talk about bioregional planning.
Thanks, Revel. So the reforms also introduce a new framework for bioregional planning, which will include a fast-tracked pathway. But just to take a step back, there is bioregional planning provisions in the EPBC Act currently. They haven't been used much, and they're really only around guidance and information style plans. What we're going to see now is two new types of bioregional plans under the Act. We'll have bioregional guidance plans. So they're going to have no regulatory function. They're going to essentially be information style plans, which will talk about, the values of a certain region, the threatened species there, etc. But they won't have any regulatory function. And then we'll have the bioregional plans, which is where the regulatory function will be. And these are the plans where we will see development zones and conservation zones, and also bioregional restoration measures. Bioregional restoration measures are essentially offsets at a regional scale. So in terms of the development zones, there will be areas in your regional plan that say where the development zones are, and within those development zones, there will be priority actions, which will be actions that can be carried out under that development zone only with a registration request by the minister. So there won't be full EPBC Act assessment and approval. You would simply need to register your request with the minister that you want to carry out a priority action. You'll need to be able to show that you can carry out the action in accordance with any conditions set under the plan. The minister is able to consider the environment record of the proponent and whether they'll be able to meet the conditions, but essentially can give it the tick of approval, and then that priority action can be carried out. There would be no consultation in relation to priority actions. As Revel did mention, though, one of the changes that was made in the Senate the other week was that fossil fuel actions are now unable to be declared priority actions in development zones. So that's an improvement on the bill as originally introduced into the Parliament. On the flip side, the bioregional plans will also have conservation zones. They're being described as no-go zones, but they're not necessarily no-go zones in the way that you or I might think about them. So they don't provide comprehensive protections for values across the region. For example, they're not necessarily going to be required to protect all Ramsar wetland or all critical habitat. The legislation is silent as to what values you might be able to protect through a conservation zone. It will be determined on a case-by-case basis as the regional plan is developed. And also the no-go zones don't provide a blanket restriction for actions. Only declared restricted actions will be unable to be carried out in a conservation zone. Other types of actions could still go ahead, with a proper application and approval process. It's only the restricted actions that can't be carried out. But even then, the legislation still includes an exemption that allows the minister to exempt those certain actions from being restricted actions. So conservation zones don't have the type of teeth that we would have expected a conservation zone that's being described as a no-go zone to have. So we'll definitely be watching this space as bioregional plans are developed. It's unclear whether or not the government intends to develop a national environmental standard for regional planning. It was something that was recommended by Samuel and something that was considered by government, but there hasn't been much talk about whether there will be a national environmental standard for bioregional planning under the current reforms. So it's definitely a watch this space to see how this is rolled out moving forward. I'm going to throw to Rachael now, who's going to talk about the national interest exemption.
Thanks, Cerin. So another new fast-tracking pathway that has been inserted into the Act is a new national interest proposal approval pathway, which enables the minister to declare almost any project a national interest proposal if the minister is satisfied that an outcome of that project is in the national interest. In this context, the national interest is extremely broad. The minister may consider Australia's defence, security or strategic interests, or Australia's obligations under an agreement with one or more other countries, but this doesn't limit the matters that the minister can consider. The minister can make a declaration on their own initiative or on the application of the proponent. And where an action is declared to be a national interest proposal, it is exempt from complying with national environmental standards, can still be approved even if it will have an unacceptable impact, and does not have to meet the net gain test. This is a highly concerning power given its breadth and the significant discretion given to the minister. However, a small safeguard on this power was secured in the Senate. As with other streamlined pathways, a fossil fuel action cannot be declared a national interest proposal. We're running a little bit behind, so I'll skip the case study that comes next, except to say that where a project is declared to be a national interest proposal, an action that would have the impact of removing swift parrot habitat that was critical to the survival in the wild of the swift parrot would be allowed. And you can see that when we send around the slides. Other changes to the Act that I'll run through very quickly include curtailing the ability of the community to request reconsideration of controlled action decisions. And this is something that I know is probably of significant concern to a lot of the people on this call. This provision has been used by community and environmental groups to formally require the minister to consider new information about an action or an impact the action will have while the action is still under assessment. The amendment's effectively new to this provision by introducing a 28-day time limit on when a person other than the proponent can request reconsideration of a decision that the action is or is not a controlled action. This is a blow to community rights and accountability under the Act. Another new power introduced into the Act is for the minister or the CEO of the EPA to make rulings under which the minister or the CEO can, on their discretion, make a determination setting out their opinion on the way in which provisions of environmental laws should apply in relation to persons, activities, and other matters. These determinations are generally binding on decision makers who will be required to act consistently with rulings. However, if a decision maker is satisfied that it is not appropriate to follow a ruling in particular circumstances, they may deviate from the ruling but must publish reasons for doing so. This sort of power to make binding rulings is very unusual and doesn't, to our knowledge, exist in other environmental laws in Australia. It appears to be inspired by the rulings feature of the Taxation Administration Act. However, it's obviously a very different legislative scheme, and the power under the Taxation Administration Act is exercised by the Independent Commissioner of Taxation, not as is proposed here by an elected minister who is a politician. A final change that we'll speak to is that the reforms have also introduced provisions allowing the minister to issue protection statements. These statements are intended to clarify what a decision maker must consider during the approval of actions in protecting threatened species or ecological communities. Protection statements could be a useful tool that supports the implementation of new environmental protection mechanisms in the Act, such as considering whether a project will have unacceptable impacts. However, as drafted, the Act makes these new protection statements the primary regulatory document, which will override requirements relating to recovery plans and conservation advices. Instead, the reforms will require only that the Minister not act inconsistently with protection statements. In our view, this is a backward step, and it would have been more appropriate that protection statements complement and not override or diminish the role of existing conservation planning documents, such as recovery plans, threat abatement plans, and conservation advices. Now over to Revel.
Thanks, Rachael. So on to unfinished business. The reforms do introduce some changes around considerations of climate emissions, greenhouse gas emissions. There is a new requirement to disclose only scope 1 and 2 emissions above a certain as yet unspecified threshold that will come through with the further regulatory provisions as to what that threshold is. There is no requirement to disclose scope 3 emissions, which is obviously incredibly disappointing given the extremely large contribution that our scope 3 emissions have in Australia to global emissions. And the fact that many proponents actually have been putting in scope 1, 2 and 3 emissions into their applications under EPBC assessment to date, probably because in New South Wales and Queensland, there is already a requirement to disclose and assess the contribution of scope 1, 2 and 3 emissions. So it's disappointing that our federal legislation still lags so far behind in terms of ensuring proper assessment of climate change impacts of activities put forward. There is also a new requirement for a proponent with emissions above whatever threshold is specified to provide strategies and measures to actually manage those emissions. And those attempts to manage the emissions will be assessed against other Australian policies, including potentially our emissions reductions targets. There isn't a requirement to consider scope 1 and 2 or 3 emissions in assessment. However, there is nothing preventing a decision maker from doing so, as existed in the previous version of the Act. Decision makers were considering the impacts of emissions proposed by a project on matters of national environmental significance, such as our Great Barrier Reef, particular species. Probably all of our matters of national environmental significance are at threat from greenhouse gas emissions. And so these emissions can still be considered in the assessment process, including potentially scope 3 emissions. It's just whether that information is actually put forward in applications we'll be yet to see. Possibly responsible operators could still put that information in their applications. They're not hindered from doing that and from that being considered an assessment. As we mentioned, there were amendments secured in the Senate to actually exclude fossil fuel actions from fast tracking, which is obviously beneficial for ensuring better consideration and regulation of greenhouse gas emitting projects. Watch this space for the review of the safeguard mechanism, which is coming next year and will be an integral moment for actually improving, hopefully, how emissions reduction work actually occurs under the safeguard mechanism, which is currently the federal government's only way of attempting to regulate greenhouse gas emissions, and it is currently failing to do that job. So a lot of work needed in that space, and EDO will be helping with submissions and engagement with that process going forward. I will throw to Rachael Walmsley now to wrap up on the next steps on this package to make sure that it actually leads to the strongest environmental laws possible.
Thanks so much. I hope you coped with that whirlwind tour of some very technical changes to the Act. I think with Revel talking about unfinished business there, clearly climate is a massive piece of unfinished business and a disappointment from these reforms. But one of the other wins in the Senate was the Act will now be reviewed every 5 years instead of waiting 10 years to hear it's failing. And of course, EDO and all our colleagues will continue to push for climate to be embedded, not just in the EPBC Act, but across all decision-making laws in the country. As you've heard today, we've had some wins in the Senate, but there's a whole lot of really, really crucial detail that is now to be decided. So we've got some next steps pointed here. Things like the national environmental standards that Revel talked about at the start. We've got 2 out for exhibition until January. So we've got the offset standard out and a standard for matters of national environmental significance. They're being exhibited now. We've got preliminary thoughts on those. They're not as detailed and granular as Samuel wanted. So there's a lot of work in making those as strong as possible. If you go back to that slide, thank you so much. We've got regulations coming out. They're going to be critical because it's the regulations that are going to say what standards apply to what decisions. There's a whole lot of detail that's going to be really, really important there. As our offsets guru Cerin said, we've got charges, we've got calculators, we've got the offset standard, and a whole lot of scrutiny required in terms of how that framework rolls out. And with the accreditation and devolution of powers that Revel was talking about, in each state and territory, in our view, no state and territory currently meets even the basic federal standards. So any attempt at accreditation of a state or territory or other body, we need to absolutely go through with a fine-tooth comb and make sure standards are being met. And the precursor to that is actually making sure we have a full suite of really robust standards in place before any of that happens. There's a lot of opportunities. We're looking at test cases to test some of these new concepts like unacceptable impacts. What can we put in protection statements to actually define critical habitat, prevent unacceptable offsetting? There's so much work to be done. We're going to take a breath and enjoy a bit of Christmas, but we're right back into this next year. And in this slide pack that we'll send around, we've got a lot more detail about the next steps, and we'll send some more in the afternoon. But if we can just go to the very last slide now, we've got a couple of questions coming through in the last couple of minutes that we'd love to go to, and we will send this further information out this afternoon. The first question from Susie: would the unacceptable impacts likely rule out the logging of swift parrot habitat in New South Wales and Tasmania? I might throw to Cerin for that one, please.
Thanks, Rachel. Thanks for the question, Susie. It's a good one. I don't think we can say definitively that the unacceptable impacts is going to do anything at this stage. How it's applied is going to have to be on a case-by-case basis. In terms of your specific question about the swift parrot in New South Wales and Tasmania and the logging, we need to remember that the RFA and the Part 3 exemption will still be in place for at least another 18 months. So it won't have, the unacceptable impacts test won't have any application there. After that, once logging, the Part 3 exemption no longer applies to logging, then the unacceptable impacts definition and requirement is likely to play a role, but it's going to have to require establishing, meeting those tests that I talked about in the definition. So in the case of the Swiss parrot, and I'll go back to the definition that we had there, which is a critically endangered species, we're going to have to be able to demonstrate whether or not the logging operation, whether it's an individual case-by-case project or whether it's going through a strategic assessment pathway, whether those operations would seriously impair the viability of the list of threatened species. So we're going to need some ecological expertise on that. And whether it causes serious damage to critical habitat, which is a defined term in the Act. So we're going to have to figure out what the critical habitat is for the swift parrot, and then whether or not the habitat is replaceable and necessary to be listed for that species to remain viable in the wild. So lots of technical questions that I can't answer today. I don't think anyone would be able to answer today. It's going to require, pulling together that evidence, considering the specific logging operation that's being proposed, looking at the definition here, and trying to make the case that there would be unacceptable impacts as a result of that operation on the swift parrot. So sorry that I don't have a definitive answer for you there. I just think unacceptable impacts is one of these ones that we're going to have to pay close attention to and work together to figure out what type of information needs to be put before the decision maker so that this mechanism becomes something useful in practice.
Thanks, Cerin. I think we've got time. We'll squeeze in one more cheeky question and we'll respond to your other questions in due course. Can the public appeal a streamlined decision? Might throw to Rachael Chick, please.
Thanks for that question. The amendments that have just been made don't change the existing provisions relating to extended standing for members of the community who meet certain criteria to be able to challenge decisions or seek to enforce the Act if there's been a contravention. So that applies to the streamlined assessment pathway as it does currently to other decisions under the Act. However, that refers to judicial review, which is just about the legality of a particular decision. So that means basically whether the process was followed, and not merits review. So not on the actual reasoning or the evidence on which a particular decision was made, which was actually a recommendation that Graham Samuel made to provide limited merits review with respect to particular decisions.
Thanks so much, Rachael. We're at time. I'll just note a couple of other questions. What will the government do to protect against panic logging over the next 18 months? Great question. As we said, we were very happy that the royal assent happened and that the laws have commenced, and the minister made a statement in Hansard about getting the new EPA up and running and doing enforcement. But I absolutely think there's a role for third parties and everyone to get the drones up, see what's happening, right in, because we all need to work together to get these laws enforced and make sure they work. And another question's come in, will EDO be able to help guide the public with submissions, standards, regulations? And yes, absolutely, of course we will. We're going to be publishing a whole lot more on our website of analysis and the next steps about what's happening, what the opportunities are to put submissions in, and the technical detail. As Cerin said, it's very complicated, but we're absolutely in them. We will be publishing things. So anyone who's joined the webinar today will be sending out some information. And I'd just like to say a huge, huge thank you to those of you on the call who've worked on EPBC for many years with us. You're all brilliant. Take a breath. This is a step forward. A whole lot more work to do. For those of you who've supported EDO, and funded our small but mighty law reform team, massive, massive thank you to you. That's meant the world to us to be able to do this work. And I wish you all a very, very peaceful holiday break. Get into nature, see some matters of national environmental significance and some of our iconic nature, and hopefully that will rejuvenate you. So in January, you can join us with submission writing on standards and regs and everything else. But thank you so much for your work and your support this year, and we'll be in touch with more information. But thanks so much for joining us today.